Hello friends, welcome to VSP Law channel. Thank you for clicking this video. Today's session we are going to discuss the clarification by the Honorable Supreme Court of India regarding armed forced personnel liable to face a disciplinary action for adultery despite striking down of the section 497 of the Indian Penal Code. So this is a clear clarification by the Honorable Supreme Court delivered on 31st/1/2023. So let us discuss. In 2019, Defense Minister for Defense, Union Government referred the matter before the Honorable Supreme Court of India, consisted 3 justices, regarding the whether armed forces personnel liable to face disciplinary action for adultery despite striking down of 497 of the IPC by the Supreme Court in the 2018. So the 3 justice bench, the matter referred to the 5 justice constitution bench, and the 5 justice constitution bench, namely K.M. Joseph, Justice Ajay Rastogi, Justice Anirudh Bose, Justice Arishikesh Roy, Justice C.T. Ravikumar, delivered the judgment of the clarification on 31st/1/2023, stated that armed forces personnel liable to face disciplinary action for adultery despite striking down of 497 of Indian Penal Code by Supreme Court in the year of 2018. So while clarifying the judgment, the court stated that so in the year 2018, 497 of Indian Penal Code section was struck down by the Supreme Court, will not impact on armed force officers or military, especially in court-martial initiating the proceedings against personnel serving the armed forces for adultery conduct. It means the section, the strike down of the 497 of IPC will not impact on court martials to take action against the armed force personnel who committed adultery. Clear means court martials, the military, the armed forces have the laws, will take action as per their laws, will take action against the armed force personnel who committed adultery. So 497 of the IPC will not impact on that laws. And the Supreme Court also be observed in order that in 2018 judgment, Joseph versus Union of India was not concerned at all with the provision of the Armed Forces Act. And also the court further noted that under Article 33 of the Constitution, legislation governing the armed forces can provide an exemption from the fundamental rights. So, here is that clearly in the year of 2018, what are the judgment given by the Supreme Court in Joseph versus Union of India? I upload a video, can see that judgment. So, under that judgment, that Honorable Supreme Court abolished the section 158 years old section 497 of the IPC was abolished. Clearly, 158 years old law of the adultery was abolished and striking down by the Supreme Court in Joseph versus Union of India. So the section is saying about adultery means is the illegal relation. Under this section, the case was registered. So that is was struck down by the Supreme Court and abolished by the Supreme Court in the year of the 2018. So that is not impact the Armed Forces Act. It is not concerned with the Armed Forces Act. If armed force personnel committed any adultery or illegal relations, then the person shall face a criminal proceedings as per court martials. So this is a clarification from the Honorable Supreme Court that here is that military or armed force personnel who committed adultery, then it shall face a criminal proceedings, disciplinary action from the Armed Force Act. So IPC section 497 will not impact on that laws. They cannot take the plea of the striking down of the 497 of the IPC. So friends, this is the topic. It clear that the Supreme Court clearly clarified that armed force personnel liable to face disciplinary action for adultery despite of striking down of 497 of the IPC in 2018. It means armed forces shall face a disciplinary action as per Armed Forces Act. 497 of the IPC will not impact. So this is the topic, friends. I hope you understand. Please like, share, subscribe. Please forward to your friends. Thank you one and all.